Hello and welcome to the Rodgers Brief. I'm Adam Rodgers. Thank you for watching and thank you for listening. This is my continuing series where I read from my ebook, Deficits of Trust, which is the Rodgers Brief report on the mass shooting of April 18th, 19th, 2020 and the commission of inquiry that followed. I'm going to read today from part 3, which is called Traumatically Misinformed, the Nova Scotia Mass Casualty Commission. And these probably read 3 sections, starting with section 8, which is Disorienting, Not Trauma-Informed Approach to Evidence. And then I'll read the section Attending the MCC In Person, more like a seminar, and then Withholding Big Stop videos. I think I'll probably get to those 3 sections today. If I have time and we can just keep on going, we'll do so. Okay, so this is the Disorienting, Not at All Trauma-Informed Approach to Evidence. Early on in the Mass Casualty Commission proceedings, the process designed by the commissioners seemed intended to sap as much dramatic interest as possible from the proceedings, as though that were synonymous with being trauma-informed. Witness statements and officer notes were being published in full, parties had been forced to beg for witnesses, lawyers had to give advance warning of their lines of questioning, police were all trying to exploit trauma-informed into a blanket exemption from testifying, and despite all the talk about Portapic, we had not yet heard a single word spoken from a person who was actually there. The material that is still available on the Commission website is a treasure trove for the curious. Full transcripts of witness statements, officer notes and reports, phone records and maps of the area have been made available. At times, it feels invasive, especially when reading about interpersonal relationship histories and other personal matters which can arise in a thorough police interview, but which have no real bearing or pertinence to significant facts. These kinds of statements are not typically made public. Instead, each of the lawyers would be given a copy of the statement, any part of which they could reference when the witness testified, if they felt it might be relevant to the matter at hand. Among the benefits of doing things that way is that parts of the statement that may be embarrassing or otherwise sensitive and not germane to any key fact do not become public. With multiple lawyers examining each witness, it would have been safe to expect a thorough review of the relevant portions without providing the entire statement to the public. The better, more trauma-informed approach would have been to provide the parties with the statements and then lead the witness through the relevant parts of the story on the stand. Taking this approach could also likely have allowed the Commission to start hearings weeks earlier. One thing that became clear to anyone observing the first few days of proceedings was that there were a variety of interests at play in the proceedings. Public interest in the Mass Casualty Commission was part of the field of battle among these various interests. It was in the interests of the families and community members and all those who want to see changes emerge from the MCC for that interest to remain strong. The police and government interests, on the other hand, were served if interest dropped off. The MCC seemed to be siding with the police and government interests in that sense. For example, instead of the stoic 6'5" Mountie Stuart Basselt leading off proceedings with a first-hand account of the harrowing first steps into Portapic, we had kindly, self-deprecating former legal aid lawyer Roger Burrell giving us what amounted to an extended TED Talk. Then, instead of allowing for the possibility of a witness being surprised by cross-examination questions and thus revealing something they were otherwise trying to conceal, the lawyers for the parties were forced to show their hands and reveal what questions they intended to ask, failing which, whatever witness they had in mind would not be asked to appear. Not only did this give witnesses a chance to prepare, but it removed much of the dramatic energy when we all knew the questions that were coming. Another public interest maneuver I noticed was that the MCC would release a bunch of news all at once in the form of document releases, rather than having it unfold day by day. We knew well in advance what any witness might say, or at least most of it, before they took the stand. The Commission must have been conscious that this would mean fewer people would be inclined to take the time to watch such witnesses. In fact, the Commission, with their large PR staff contingent, must have been conscious that all of these features of the proceedings Not to mention, starting proceedings with a highly technical witness presentation on the 911 system that would have fit just as well at a later stage would reduce public interest. The Commission may not have considered it their responsibility to be interesting, but they should have been aware of how their decisions would impact the engagement level of the public. Judging by their limited remarks during the requests by the parties for particular witnesses, the commissioners seemed inclined early on to adopt a default position of no witnesses being called to testify if it could be avoided, seemingly believing that being trauma-informed meant avoiding trauma at all costs, even at the cost of accurate fact-finding. That was not even the most misguided interpretation of the Commission's trauma-informed mandate. The National Police Federation argument that none of their officers should be subjected to the potential trauma involved in testifying to what they saw and did was outrageous. That the MPF would even make a straight-faced attempt at this argument was a sign of how malleable the term trauma-informed had been allowed to appear. The NPF made a serious strategic error, however, in trying to exploit the mandate in this manner. Just because you can think of an argument that might help your ultimate position does not mean you should always make it. The NPF looked like they had something to hide, made all the worse when their proposed expert on the question, Dr. Nick Carleton, had his qualifications rejected, in an exchange that also certainly highlighted the potential benefits of an effective cross-examination. After one of the family's lawyers, Rob Pinio, was finished with him, it was clear to anyone watching that Dr. Carleton was going to provide biased conclusions of limited scientific merit. The NPF had wished him to be called to give expert testimony on the issue of the trauma officers experience when they are made to testify about cases they investigate. It was quickly determined that Dr. Carleton should not be qualified as such an expert. He had never been qualified as an expert before in court, and had not even conducted his own studies in this area, but instead had simply done a review of studies done by others, what academics would call a document review. His answer to the question as to whether he had been qualified in any court previously may alone have determined his fate. When he was asked by Mr. Pinio whether he had been qualified as an expert before, he said, "Not to my knowledge," which is always a red flag answer, and here all the more peculiar, since being considered an expert in court is usually a highly prized status for academics and so unlikely to be forgotten. Many experts will list the times they have been qualified as an expert in their resumes. The commissioners quickly rejected the application to have him named an expert, and for the rest of the inquiry, the MPF was fighting unsuccessfully to regain credibility. None of this was fair to the public. Questions as to who would testify should have been determined long before the hearing started, with trauma-informed support allowances made when needed, so that when proceedings started, we could have heard what happened from the people who were there. We did not, and may never fully get that opportunity. We heard from some of the officers on the scene, but never heard from the citizens of Portapique or other communities along Wortman's path of destruction. It was not until day 4 of proceedings that we even heard from our first witness. That morning was occupied by a presentation by the commander of the Operational Communications Center, Daryl McDonald. Mr. McDonald may technically be considered a witness of the MCC, but the evidence unfolded like a pre-scripted discussion between Commission Counsel Jennifer Cox, KC, formerly of Dalhousie Legal Aid, and Mr. McDonald. He talked about how the 911 system works in Nova Scotia. His testimony was heavy on technical detail and in some seemed to show that the system works very well and that things happen on a very timely basis. We had our first look at how cross-examination questions from the other parties would be handled. It was certainly not the same as a regular cross-examination procedure. Mr. McDonald finished his direct examination with Ms. Cox just before the lunch break. Over lunch, the lawyers for all parties discussed potential cross-examination questions, and when the MCC was back in session, Commission Counsel, Ms. Cox, indicated to the commissioners that there were questions the parties wanted to ask that she felt were valid. The commissioners then stated that they would allow some questions, starting with some from Ms. Cox on behalf of the parties, followed by a few questions from 4 other lawyers. Telling the government your questions in advance is unheard of, as is having another lawyer ask your questions for you. Both were demonstrative of an effort at controlling the process and narrative. When one of the lawyers, respected Birchall McDougall partner Stephen Topshee, asked a question that seemed not to have been anticipated, it was Ms. Cox who spoke on behalf of the MCC, not any of the commissioners. After 4 days of sitting and listening, the Commission finally allowed the participants to make submissions regarding any gaps they felt might be relevant with respect to the factual record to that point, and any recommendations they may have for further witnesses and evidence that might fill in those gaps. This was the first real opportunity to openly challenge the Commission's work, and they each did so to various degrees. Some of the tension that had been taking place mainly behind the scenes was exposed in the first presentation from Patterson law lawyer Sandra McCullough. In her submission on behalf of the many family members that her firm represents, she said that the families were disappointed with the proposed procedure, that they expected they would be speaking about any relevant gaps they had identified in the evidence presented to date, as per Commissioner MacDonald's opening comments, but were told by Commission Counsel that they would be limited to proposing individual witnesses and giving reasons for those individual proposals. Ms. McCullough stated that the foundational documents that they had been provided were significantly different than what were entered as exhibits this week. She said 2 of the 3 doubled in size while the other was reduced by half, and that Patterson Law did not endorse the documents as presented. At some stage, which they had hoped would be that day, they wanted to be heard about their disputes with the narrative as presented so far. Commissioner MacDonald said that time would come at the end of Phase 1 of the MCC, which Ms. McCullough correctly noted would mean the existing and, in her view, problematic narrative would become unduly settled in the minds of the public. Some of this raised questions as to who was in charge of the Commission. Commission lawyers seemed to be trying to play the role of gatekeeper to a significant extent. Before any submissions were made, lead Commission counsel Emily Hill stated that the Commission lawyers felt the factual record was adequate as it was presented in the documents and that no witnesses were required. There had been requests from participants to have 18 various non-commissioned police officers brought before the MCC to provide testimony. In the absence of the parties having had the opportunity to make opening statements, which would have otherwise been a way for the public to see what kind of approach each of the stakeholders was planning to take, these requests for witnesses gave us a good sense of each party's interests. In particular, the lawyers for the National Police Federation and the RCMP were consistently opposed to any police witnesses being called. In each case, they attempted to base their positions on the mandate of the MCC to be trauma-informed. To the extent that the police lawyers agreed that there were any gaps in the evidence, and such agreement was very limited, they said that statements given by the officers or interviews the officers provided to Commission counsel should suffice as evidence. If any questions remain after that, the police lawyers say those questions could be submitted in writing to those officers. It was not clear how the commissioners might address these requests. Commissioner Stanton, who, recall, had just released a book on alternative ways to conduct an inquiry, challenged Patterson Law's Michael Scott in particular on the question of how useful any new evidence might be, and suggested that Patterson lawyers had ample opportunity to help shape the foundational documents. Mr. Scott echoed some of Ms. McCullough's earlier comments in disputing that contention. Each potential police witness was discussed individually by the lawyers who wished to be heard. Mr. Scott spoke well about the broad need for witnesses from the perspective of the public interest, and others were very effective in pointing out specific points that had not been covered by the existing statements. From the decisions by the first officers on scene to stay on foot, to the interactions with the children that had to wait 2 hours to be evacuated, to the discussions around containment points. In all cases, the lawyers for the police and the questions said the questions could be answered in writing, or the details may come in later foundational documents. With each witness that was proposed by the parties, Commission counsel made short responses indicating their position that the particular witness was either not needed or that the question of them appearing was premature and should await further developments. This later position extended to the most obvious of potential witnesses, Ms. Banfield. Ms. McCullough, Chester Law's Joshua Bryson, Birchall McDougall lawyer Linda Hupman, and MDW Law's Tara Miller KC each provided cogent reasons at this early stage why Ms. Banfield must be called as a witness. One of Ms. Banfield's lawyers stated out loud something that hinted at negotiations that were likely taking place behind the scenes. That if Ms. Banfield did not have to worry about her criminal charge, she would be fully cooperative with the Commission. While making such a demand, if that is what it was leverage that she did not actually have, it also would not have been unreasonable to wait until her criminal trial was complete, as that was to be done on April 5th, 2022, to have her testify. Ms. Hill urged the commissioners to wait until Ms. Banfield's trial happened before addressing the question of her testifying. But in my view, there were enough known elements at the time for the commissioners to have made a ruling as to what they would do. The only real unknown was whether the trial would actually go ahead as scheduled. Again, this was an early sign from the MCC lawyers as to how they might misinterpret the trauma-informed mandate throughout the proceedings. This all presented a challenge to the MCC to define more specifically what they mean by trauma-informed. It was clear that Commission counsel would be advising against any meaningful witnesses, and there was disagreement among the other participants, so it was up to the commissioners to make a ruling that gave the parties and the public some clarity. Attending the MCC in person, more like a seminar. On day 12 of proceedings, I attended the MCC proceedings in person for the first time and heard the foundational document presentations on the police shootings of the Onslow Belmont Fire Hall and the subsequent events in the Shubenacadie area. Those later events included the deaths of Constable Heidi Stevenson and Joey Weber. There was also a witness panel from the fire brigade which featured Chief Greg Muse, Deputy Chief Darrell Curry, and Richard Ellison. The proceedings were taking place in a cavernous room in the new Nova Center, where the setup lent the proceedings more of a feel of a law conference than a courtroom. The presentations and panel discussions reinforced this conference feeling. There were some other differences as well. While witnesses were sworn or affirmed as they are in court, they are not called to the stand as they are in court, but rather invited to the witness table. It was hard to tell whether any of the distinctions between the MCC proceedings and a court process had any effect. It may be that witnesses felt less gravity or solemnity being called to a table rather than a stand. Another was, unlike with a judge entering a courtroom, we did not all rise when the commissioners enter, which was disconcerting for my lawyer reflexes. The Onslow Belmont panel was a valuable exercise, and the participants demonstrated courage by attending and speaking out. There should have been more sessions like that, with people involved having a chance to speak. It was clear, however, that from the MCC perspective, this was a performative exercise, rather than an attempt to actually learn anything. The MCC lawyer had clearly practiced their exchanges with the witnesses and was not inclined to deviate from his script. Such an interview approach can carry the risk of losing the natural energy that comes with telling a story. That did not happen here, thanks to the energy from the witnesses. But what did happen was the MCC lawyer seemed unable or unwilling to ask obvious follow-up questions when unexpected answers or comments took place. For example, when Deputy Chief Curry said he did not believe Constable Terry Brown, and when Richard Ellison said he had previously seen Wortman's illegal guns, the comments were just left hanging. This demonstrated that the MCC was not so much looking for answers or information, but rather just wanted to placate witnesses and community members by allowing some to share their experience. As we delved further into the Mass Casualty Commission proceedings, we saw a variety of formats for the conveying of information. Early on, the MCC proceedings featured 6 individuals in what was called a roundtable discussion, answering questions about police paraphernalia and those who impersonate police officers. For this panel, Krista Smith from the MCC was the moderator, and the speakers were former Kentville Police Chief Julie Chiquetto, retired RCMP Officer Brian Carter, retired Edmonton Police Inspector and memorabilia collector Phil Bailey, self-described settler lawyer Megan Daniel from Montreal, and Oxford University professor Ian Loader, speaking from Melbourne, Australia. Mr. Carter spoke about earning your uniform as an officer and that the ceremonial uniform was an important possession for retired officers. Mr. Bailey spoke about the community of collectors and how collecting and exchanging memorabilia can be a social connector with other police officers. Chief Cicchetto was less sentimentally attached to the police uniform or paraphernalia and suggested that if citizens were unsure of whether someone is an officer, they should call dispatch for confirmation or drive to the police station and have the status confirmed. That last suggestion struck me as being a very unrealistic possibility for how a citizen-police interaction might unfold. There were comments on the pride that retired officers feel for the uniforms and symbols of their police force, their abhorrence for any officer who would abuse the privilege of possessing the uniform, and how difficult it would be if we could not trust that police officers are real officers. The key points from the day came from Professor Loader and Miss Daniel. Professor Loader noted how venerated and revered the RCMP brand has become, like the British police, and that it is difficult to have a sober conversation about reforming police structures and practices because of that status. Ms. Daniel added that for marginalized individuals, the brand is not a symbol of safety, but rather terror. She also made an important point when asked about the risk-benefit analysis of allowing police memorabilia to be possessed outside of actively serving officers. She said we should look at who bears the risk and who gains the benefit when we ask that question. Another report presented by MCC lawyer Amanda Bird was on the forensic evidence that was discovered at the various crime scenes. I noticed that Ms. Bird became emotional when going through the forensics report with respect to the death of Kristen Beaton. Though these are reports about deaths, the details are somewhat technical and repetitive in nature, and Ms. Bird's voice and affect had been fairly flat until that point, making the onset of the emotional reaction all the more unexpected when it happened. It made my focus wander from the evidence to wonder what was causing that emotional reaction, which I suspect others listening were doing as well. I point that out only to note for young lawyers that it is important to control your emotional reactions at such times so as not to detract from the evidence or your credibility as a professional. After the first presentation, we received 2 presentations from Ms. Cox. These were presentations of expert reports by St. Mary's Professor Blake Brown and University of California, Santa Clara Professors Tober and Bridges. I had expected that we would be hearing from the experts directly, potentially with the chance of them being subjected to follow-up questions or cross-examination from counsel for the other participants. This was not to be, and for some reason, Ms. Cox presented both reports herself. For many Nova Scotians, or at least those over a certain age, the gold standard of inquiries in Nova Scotia and perhaps Canada is the Marshall Inquiry, which had only 3 lawyers, 1 investigator, and 1 communications person. The Mass Casualty Commission, on the other hand, has at least 15 lawyers, 8 investigators, and 4 communication staff. Perhaps the strategy of having various lawyers conduct presentations is a way of giving each some public speaking parts, but it is not the best way to present an expert report, particularly when it would have been so easy to have the expert appear by video to make the presentation themselves. As the witness who appeared that day, Benjamin Sampson, later spoke by video from Toronto. Mr. Sampson was listed as a technical witness and certainly lived up to his billing. He testified about the methods used by forensic labs to identify how bullets are linked back to particular firearms. This testimony connected back to some of what Ms. Bird had presented in the morning, and hearing it in isolation made me think it would have made sense to have Mr. Sampson analyze the individual details of the casualties and crime scenes while giving his evidence, rather than separating the 2 sides of the story. So, instead of making this natural connection, we had the disorienting experience of Ms. Bird listing the forensic details of each deceased in the morning, and Mr. Sampson talking about how conclusions on the forensic evidence for each may have been reached in the afternoon. It almost seemed purposefully designed to make it all less interesting. After the witness was done, the MCC took a break so that the lawyers for the participants could meet and determine what questions, if any, they had for Mr. Sampson. This process is highly problematic. There is no reason why an MCC lawyer should be involved in any way in this meeting, nor should the lawyers for the participants need to have their topics and questions approved in advance before they can ask the questions. If there is an improper question asked, any lawyer could have raised an objection and put their position on the record publicly. I would have liked to see this requirement challenged more often by lawyers during questioning, asking unapproved questions to see what would happen. That would have helped expose this improper restriction on cross-examination to the public and may have forced the MCC to explain why they were doing things that way, or else relent and allow more open questioning. Withholding the Big Stop videos. Monitoring the potential lines of questioning is hardly the only instance of the MCC tightly controlling the proceedings. One of the more insightfully problematic instances of this overdeveloped instinct to control the narrative and to take the trauma-informed mandate too far relates to the video of the killer's final moments at the Big Stop, which for months the MCC refused to allow be disclosed or played publicly. The 6 surveillance video feeds from the Big Stop were provided to the media, but were done so on the strict conditions that they not be used and that they be destroyed after viewing. Fortunately, on April 28, 2022, lawyer David Hutt of the law firm Birchells, not to be confused with Birchall McDougall, which represents some of the participants, on behalf of Colesfoot Publishing, the publisher of Frank magazine, wrote to the Commission asking for standing to make submissions on the use and disclosure of these videos. It appeared from the letter that informal discussions had already taken place between Mr. Hutt and Commission lawyers about this issue, which would almost always be the case before a formal application is made, but that the Commission lawyers rejected both the disclosure request and the request for standing. The Commission agreed to schedule a time for the request to be heard, setting aside 3 hours on Monday, June 13, 2022. Mr. Hutt was to have half an hour to speak, and with some time allotted for other participants, and then 45 minutes for Commission counsel. It was incredible that the disclosure and use of the best possible evidence of key moments in the mass shooting needed to be requested in this manner. In fact, Commission lawyers should have been supportive of the application. It would have been very enlightening to hear their stated position. Given the comments in the MCC's interim report about the lawyers for the Commission having roles equivalent to, or at least similar to, those of Crown prosecutors, that is to say, they are obligated to seek justice and not victories or convictions, we should have been able to expect that these lawyers would support Frank Magazine's application. In the interim report, the Commissioners identified that Commission counsel are to be objective and impartial, that they must ensure that all matters which bear on the public interest are brought to the attention of Commissioners, and that they shall act impartially and thoroughly with the goal of assisting the Commissioners in arriving at the truth by ensuring that all issues, all evidence, and all significant theories are brought forward. Any reasonable reading of these guidelines would confirm that the disclosure and use of a video showing the dramatic final moments of the killer's life should be supported by Commission lawyers. In his letter, Mr. Hutt suggested that the videos may raise questions about whether the RCMP knew who they were intercepting when they arrived, which would contrast with the version that was published in the foundational document on the subject. Rather than dissuading Commission counsel, such a suggestion should have made it all the more pressing that the video be disclosed and broadcast for the public to see. It was unfair that Colesfoot's Publishing was forced to spend money to fight this battle. It was also somewhat concerning that none of the other participants had publicly raised the issue. If the Commission lawyers were not effectively representing the public interest, and the participants, whose lawyers are all being paid by the government, would not or could not do so, then there remained an open question as to whether the public interest was being adequately represented or served by anyone. It seemed that the most likely reason for opposing the disclosure of this video was that it may have undermined the heroic narrative that the MCC had presented. That should not have been a consideration of the Commission. If the MCC felt the video was too traumatic to show publicly, which also could have been a reason for holding it back, they should have explained why they thought so. As it turned out, there was a negotiated resolution to the video release question, according to the applicant, Frank Magazine. They posted online that the matter had been resolved, though there was no immediate confirmation from the MCC. We had been expecting to hear about the resolution of an application to the commissioners by Frank Magazine and supported by many others first thing the following Monday morning when the application was to have been heard, but strangely there was no mention of the videos at any point during the day. This would seem to have been contrary to the expectations of the applicant when the settlement was reached, so something may have gone on in the background. Whatever it was, the commissioners evidently felt no compulsion to tell us anything about it. As it turned out, everyone had to wait a full week to hear from the commissioners about the resolution of the application. The surveillance videos of the final moments of the killer's life, where he was shot by 2 RCMP ERT squad members, are now posted to the MCC website. I suspect most adults will not find them particularly disturbing to watch. There is nothing gruesome or graphic about what is visible. The most you see is car windows being shattered by bullets. The Big Stop's Pump 6 video shows actions consistent with Constable Hubley's witness account of not knowing but suddenly realizing that Wortman was at the next pump. Constable Hubley pulled ahead at the gas pump more than you probably would if you were planning to get the jump on the person in the adjacent vehicle. As he got out of his vehicle on the driver's side, he took a split second to look back inside the vehicle as he reached for his gun, then waited another brief moment before shooting. It has the appearance of a focused, athletic movement. On the Pump 5 video, just before the officers open fire, it appears that Wortman gets a shot away at himself. The car shakes just before the officers open fire, and the movement of the car seems to be more than you would expect from somebody simply shifting their weight in the driver's seat. While that would seem to support the officer's account of what happened in the very final moments, there are still questions about the approach to the pump. Reports have stated that at least some of the other pumps that Constable Hubley drove quickly past were available before the pump adjacent to that which Wortman was using. As well, the simple fact that the videos were withheld continues to foster suspicion. The actual written decision on the videos has some curious elements. For example, the commissioners state that the videos were always available for public viewing at the commission offices if anyone from the public had wished to view them. I have not seen any reference to the commissioners having indicated this availability before then, so that was difficult to accept. Substantively, the commissioners noted that they had to balance the importance of the best evidence being provided against the risk that showing the videos would sensationalize the killing or perhaps re-traumatize those involved. In the decision, they said that now that commission lawyers had recommended the release and no other objections remained outstanding, they reconsidered their initial balancing decision. What really happened, I suspect, was that the MCC lawyers were against the publication of the videos up to the point where they had to explain their untenable position, and that once that was forced upon them, they folded. After that, the federal DOJ lawyers saw the writing on the wall and withdrew their opposition as well. The commissioners also said that there was going to be a new process in play in the future for any instance where evidence is made an exhibit but not published. In such cases, commission lawyers would need to publicly state why they have withheld the exhibit from the public. That process was never used, but perhaps the requirement for the MCC lawyers to state their position publicly made them less willing to oppose publication of exhibits after that. Okay, everybody, that's good for today. That's next 3 sections of part 3. We'll come back probably in a few days' time, not too long, and get the next several sections of part 3 of Deficits of Trust. Hope everybody's enjoying these videos. I'm enjoying making them for you and reading along. And so if you enjoy that as well, make sure you like, subscribe, share that so others can enjoy it as well. So thanks for watching, thanks for listening, and we'll see you next time.